If you had to make a life-changing decision about a child, which question would you ask first? Is this child safe? Or what does the data predict? The child welfare system was built to answer the first question. But increasingly, artificial intelligence is helping answer the second. Across the country, child welfare agencies are beginning to use predictive algorithms to help screen reports of child abuse and neglect. These tools are meant to support overworked caseworkers, but because they learn from historical government data, they can also reflect the inequalities already present in the data itself. For Lauren and Andrew Hackney, that concern became personal. After rushing their severely dehydrated infant daughter to the hospital, they unexpectedly found themselves under investigation by Child Protective Services. Their referral was screened using the Allegheny Family Screening Tool, an algorithm used in Allegheny County, Pennsylvania, to help intake workers evaluate hotline reports. While these tools can help identify children who may be at risk, they can also learn patterns tied to poverty, racial inequality, and unequal access to resources. Today, I want to show you that we don't have to choose between protecting children and protecting families. My solution, the SAFE Act, does both. It's a 4-part federal framework that allows AI to support child welfare decisions, all while ensuring technology never replaces human judgment or turns poverty into a measure of parental fitness. Before we can regulate artificial intelligence in child welfare, we must first understand why agencies are using it in the first place. According to the U.S. Department of Health and Human Services National Child Abuse and Neglect Data System, Child Protective Services receive more than 3 million cases of suspected abuse or neglect every year. To help manage overwhelming caseloads, some agencies now use predictive risk models to help screen hotline reports. These tools analyze historical data to estimate the likelihood of future maltreatment and to provide a risk score that helps inform a caseworker's decision. The concern is that AI learns from past data. If those records reflect long-standing inequalities, an algorithm can unintentionally repeat them. This is known as an algorithmic bias. This creates a legal challenge. The government has a duty to protect children, but parents also have a constitutional right to the care and custody of their children under the 14th Amendment. At its core, the issue isn't about artificial intelligence. It's about people. Children have the most at stake. Missing a child in danger can have devastating consequences, while wrongly investigating an innocent family can cause lasting harm. Parents are affected too. Even unfounded investigations can involve home visits and reviews of private records. In Sinofsky versus Kramer, the Supreme Court recognized that parents have a fundamental liberty interest in raising their children, so these decisions must be fair. Caseworkers and policymakers also decide how these tools are used. AI can support their work, but it cannot replace human judgment. Civil rights organizations warn that algorithms trained on government's records may reinforce existing inequalities because families living in poverty and because of racial inequality often appear more frequently in those records. If this problem is so significant, the next question is, what has already been done? As a witnesser of child abuse myself, I know that the answer is a lot, but clearly not enough. The Child Abuse Prevention and Treatment Act, CAPTA, established national standards for responding to child abuse, while the Family First Prevention Services Act of 2018 invested in services that help keep families together before foster care becomes necessary. But neither law was written for predictive AI. Meanwhile, some jurisdictions have already begun using these tools. In 2023, the White House also issued an executive order promoting responsible AI, but it stopped short of creating binding rules for child welfare. So, while we've modernized child welfare laws and started talking about responsible AI, we've never brought those two conversations together. That's the gap my proposal is designed to close. Despite all the progress that's been made, one major gap remains. The United States still has no clear national standards for how AI should be used in child welfare. Families often don't know what an algorithm influenced a decision, what data shaped a risk score, or how to challenge it. Another problem is that the data doesn't always tell the full story. Families who rely on programs like Medicaid or housing assistance may appear riskier to an algorithm, not because they're unsafe or bad parents, but because they're more visible in government records. That can lead to false positives that put innocent families through unnecessary investigations or false negatives that leave children without protection. This year, I researched AI's influence in the field of law through my independent study class. As a student from New York, I've witnessed our state lead conversations about responsible AI through initiatives like Empire AI. That research taught me that AI isn't something to fear. It's something we must govern responsibly, especially when it affects children and families. That's why I proposed the SAFE AI Act, or the Safeguarding AI Fairness and Equity Act. This 4-part federal framework would create the first national standard for predictive AI in child welfare. Rather than banning AI entirely, it would ensure these tools improve decisions without allowing poverty or race to become substitutes for parental fitness. The first part of my plan is that every algorithm would have to earn a federal certification before being used. An independent review would test its accuracy, privacy, protections, and potential biases. Agencies would have to prove the system doesn't create unjustified racial disparities or unfairly penalize families just because they rely more on public assistance. Second, families would receive an algorithmic rights notice. If AI meaningfully influenced a screening decision, they would have the right to know. Health and Human Services would require annual independent audits to measure whether these systems improve child safety without creating unequal outcomes. Any algorithm that repeatedly fails those standards would be suspended until corrected. Finally, the Act establishes a human decision requirement. AI may form a decision, but it can never make one. A trained caseworker must make the final judgment and explain when an algorithm influenced the outcome. Congress could enforce these standards by tying them to existing federal child welfare funding under the Social Security Act, making the proposal both practical and financially realistic. After spending the past year studying AI in law, I've come to one conclusion. Innovation and accountability must advance together. At the beginning of this presentation, I asked you to look at 2 words, safe and data. These 2 words represent the challenge we face with artificial intelligence in child welfare. A risk score may be able to identify patterns, but it can never fully understand the story behind a family. This issue affects real lives, and now we have the power to change that. Now we can ensure true safety of children with the SAFE Act I previously proposed. That is why cases like Lauren and Andrew Hackney's matter. Their experience was not only important because an algorithm made every decision for them. It was important because it raises a deeper concern about whether we have strong enough protections to ensure that when technology influences decisions about families, those decisions remain fair and just. If we fail to act, we risk creating a system where families are judged by the information available about them rather than the reality of who they truly are. As we enter a new era of AI, that same principle must guide how we protect our children and our families. On the year of America's 250th anniversary, we are reminded that our nation was founded on a fundamental promise. Government power must always be balanced with individual rights. The future of child welfare should honor that same process, because no algorithm should ever have the final word on a family's future, and the law should protect the humanity behind every single decision. Thank you.